Good afternoon. Welcome to Division 2 of the Colorado Court of Appeals. My name is Matthew Grove. With me on Division 2 this afternoon are Judge Sullivan and Justice Martinez. We have three cases on the docket this afternoon. I doubt the counsel for the third case are here, but any chance we have counsel for the second case?
Yes, go on.
Okay, great. That means I can do one less spiel. Everybody should have gotten instructions when you came in. If you have any questions, please feel free to ask now or before your argument starts. But the most important things are please silence your cell phones if you have any, whether you're at the tables or in the audience. When you begin, please state your name and attorney registration number. Please remember that we are live streaming these arguments on the internet where they will live in perpetuity. So if there's any confidential information, use initials, talk around it, anything like that, just be aware of that. And if anybody needs to raise or lower the podium, there's a toggle switch there. Either it should be obvious where it is. I can't remember if it's the right or left side. And I think that's all I have. Unless anybody has any questions, our first case up is People v. Munoz, 22CA1979. When you're ready.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Julianne Farshone, attorney registration number 57876. It is my pleasure to be here today representing Ms. Kelly Munoz, who is watching the proceedings virtually. I will aim to reserve 3 minutes for rebuttal. I would like to focus on the choice of sanctions issue for the due process violation in this case, the first issue in the briefs. The core principle of imposing a due process violation, for imposing sanctions for a due process violation is to avoid an unfair trial to the accused. When a due process violation occurs following either the state's destruction of material exculpatory evidence or the police's bad faith destruction of potentially useful evidence, trial court should impose an appropriate sanction that will adequately protect the defendant's right to a fair trial. Here, a due process violation occurred, as the prosecution conceded below, when Sergeant Groulet caused the destruction of a key piece of dash cam footage that recorded Ms. Munoz's driving and the subsequent stop by marking it no citation. Ms. Munoz requested 3 possible sanctions: dismissal, exclusion of Groulet's testimony, or an adverse inference instruction. Any of these 3 remedies would have been an appropriate sanction to cure the prejudice caused by the deletion of the video because there was no comparable evidence for Ms. Munoz to use at trial. The trial court abused its discretion and reversibly erred by refusing to impose any sanction for the due process violation because Ms. Munoz was unable to show that she was not driving poorly or effectively cross-examine Sergeant Groulet without the video. Reversal of Ms. Munoz's convictions and a remand for a new trial is required.
You said the officer caused the destruction of the video. Is there a corresponding finding from the district court on that point?
I believe the district court accepted the prosecution's explanation that Sergeant Groulet marked the video as no citation and that this action is what caused the deletion. The video was still intact when it was uploaded to the police department's servers. However, because it was marked no citation, that is what led to the video being deleted after a set period of time.
Are you suggesting that there's record evidence to support that he did that on purpose to cover something up?
I think that would be speculative to say that he was trying to cover something up, but I think that his action in marking it no citation when she was clearly cited in his presence shows a willful failure to either follow an existing policy that CSP had, or that it shows that there was no policy in place governing who is supposed to be properly marking evidence for preservation. And so, although that may not be the officer trying to cover up something that he may have done wrong in the video, I think that his willful action of marking it no citation despite watching Ms. Munoz be cited in his presence is an action that deprived her of this evidence at trial.
Is there record evidence that the citation was given in Gorelli's presence? I guess I didn't see that in the record.
Yes, I believe it's on page 9 through 10 on the transcript from July 21st, 2022, where he states that he did not cite Miss Munoz because Trooper Austin was the one that cited her, but he did remain on scene after Trooper Austin left with Miss Munoz, and he conducted an inventory search of the car. So I believe that shows that he was there throughout the citation.
And then is there any record evidence that this violated policy, the fact that he marked it no citation, even though it wasn't in his presence? I mean, my understanding from the record is that since Austin gave the citation, not Gorelli, that he thought it fine to mark it as no citation since he wasn't the one personally given the citation.
Right. And so based on the answers that the sergeant gave to the court, he stated that there was no specific policy as to who's responsible for marking evidence for proper preservation. And so it seems, kind of absurd to me that the officers who were present when the citation happens would not be the one that's responsible for marking evidence so that it'll be properly preserved. Because, having someone like an evidence technician way later on who was not there for the incident that happened that led to the citation, for that person to be making the determination that the video needed to be flagged for preservation just doesn't seem like it would make sense in the way that police duties normally go.
Was there any record, is there any record of support for either of the officers knowing anything about the consequences of their marking citation or no citation?
No, I don't believe so. It appeared that Sergeant Groulet didn't have an understanding of the preservation of evidence because he stated he didn't know how long evidence is preserved for, either when it's marked properly or if it's not. And so I think that shows that he didn't have any basic understanding of what the policies he was supposed to be following to preserve evidence.
And is it correct that the source of the information that if you mark no citation, then the video cam is not retained or maintained, the source of that is a statement from the prosecutor?
Yes, I believe so. However, I do believe that Sergeant Groulet testified on direct examination to that similar process of, depending on how a video is flagged in the system, that determines how many days it's preserved for. So either 30 days, 90 days, or multiple years. That's determined by how the officer initially flags the footage.
Well, I thought you just told me that Officer Goulet did not know the consequence of marking it citation or no citation. And now I think you're telling me that he did know the consequence. It's just that he thought someone else, the other officer, was going to mark it.
I think that just shows that the officer didn't understand what his preservation duties were, because between the two of them, he should have known, as the officer who initiated the traffic stop and who's the one that observed Miss Munoz's driving and recorded it on his dash cam, that this evidence was going to be relevant to the subsequent criminal prosecution.
He should have known that because that makes sense to you and me, or he should have known that is because that's the way the State Patrol was operating?
I think he should have known that because that's how the State Patrol operates, or should be operating. They should have a set policy in place that dictates who is responsible for preserving evidence in a timely manner.
I thought they didn't.
It appears...
Or we don't have record that they did.
Correct. I don't believe we have a record that they do. The most that we have is the sergeant's statements that there was no specific policy on who is responsible for flagging this evidence for preservation.
I have a question about the proposed sanctions that defense counsel proposed. And that was, it seemed like the defense counsel gave the court kind of a menu of options, like from dismissal to an adverse inference instruction, and
Correct.
I think excluding the officer's testimony was in the middle. In your view, if the court had chosen one of those, we wouldn't be here on this issue? That wouldn't have been an abuse of discretion for the court to choose just one of those?
Yes, I believe that is true. If the court had gone with any of these three sanctions, I think that would have been an appropriate use of the court's discretion, given the lack of comparable evidence to the video. There were no still photos that were taken of the video, and no one had watched it prior to its deletion. So this is different from other cases where officers could testify to the video that they watched, or there was other video that captured the same incident just from another angle.
So why wasn't it sufficient for the court to do what it did, which is to say, look, you have, it's open season on cross-examination here, and you can take the officer to task for not doing this right. Why didn't that resolve your client's concerns?
I think that was an insufficient remedy because first, Ms. Munoz already had the right to cross-examine the sergeant, and additionally, without the video evidence, she had no way to show the jury the potential holes in his memory, given that he had lacked, or he didn't remember the stop the week before trial when he had spoken to the DA's investigator about the case. And so, because here we have no other comparable evidence to compensate for the lost video, I think that any of these three remedies would have been appropriate because we were missing that piece of it. However, I do think that the adverse inference instruction was likely the most appropriate because that would have restored the level playing field and cured the prejudice to Ms. Munoz caused by the deletion of the video while still protecting the integrity of the truth-finding process and allowing the prosecution.
Isn't the adverse inference instruction permissive? Doesn't it instruct that the inference is permissive, not mandatory, not required?
Yes, Your Honor, that's correct. The jury instructions stated that the...
So here's a problem I'm having. If you're saying that it would have been sufficient to give the permissive inference instruction, but the court didn't do that, I'm sort of wondering, is it ever an abuse of the court's discretion not to give a permissive inference instruction? Because after all, isn't it true that the jury can make the inference one way or the other with or without the instruction?
I think in this case, the way that the sergeant's...
Answer me that first. Is that correct? Without the instruction, the jury could infer adversely to the prosecution or not. Is that correct?
No, because I think the jury was much more likely to adopt the prosecution's explanation for how the video was deleted.
Aside from what the jury would be more likely to do, it would be appropriate, it is okay for the fact finder to make an inference adverse to the prosecution from the lack of that evidence or the destruction of it. Is that right?
I think that is right. However, I think that, one way the problem with not giving the adverse inference instruction is highlighted is that the court did give a refusal instruction based on Ms. Munoz's refusal to give the chemical test. And by doing that, the court was highlighting this one piece of missing evidence, the chemical test, while on the other hand, it wasn't giving a similar instruction related to the missing video. And so by doing that, the court made it seem like the video's deletion was not important to this case. And that likely persuaded the jury to adopt the prosecution's view that the video's deletion didn't matter and was just stuff in the weeds. And so I think that the instruction was necessary to allow the jury to make that presumption because without it, all they had was the sergeant's testimony and the prosecution's arguments about that, which neutralized any argument Ms. Munoz made about why Sergeant Goulet deleted the video. And I recognize I am almost at 3 minutes, so I'd like to save the rest of my time for rebuttal. Thank you.
May.
May it please the court, Carmen Moraleda for the people. My attorney registration number is 34852. So the problem with defendant's destruction of evidence sanctions claim is that she is attacking the trial court's fact findings and credibility determinations. To begin with, defendant did not argue at trial that officer, I'm gonna call him G because I have a reputation of mispronouncing everyone's last name, acted in bad faith. She can't flip her position at trial. And the record supports that Officer G did not willfully or in bad faith destroy the video. Defendant makes a leap of logic from Officer G labeling the video no citation to willfully or in bad faith and deliberate, distracting the video evidence. I think the record supports the trial court finding that this was accidental, inadvertent, certainly not in bad faith. And as to the no citation, the court asked the officer, if you say no citation, then is it typical that it would be deleted? And the officer said, I wouldn't have an idea. So he did not know. So because he did not know that by marking a no citation, it could be automatically deleted, defendant's claims to the contrary fails. And otherwise, it was for the trial court to determine the credibility of the officer, which we can't do on appeal because we just have a cold record.
What difference does it make that the court did not find bad faith? That is, if the court had found that this was done in bad faith, could it have still chosen to, would it have been within its discretion to impose no sanction at all?
Absolutely. And I think in this case, again, there was a finding of bad faith, but even if there was bad faith, which again is not supported by the record, I think the defense was able to cross-examine the officer, and the defense argued to the jury that to focus on the destruction of the evidence, and also argue that the fact that he was distracted, they could infer that it wouldn't support the officer's testimony. So that was presented to the jury, and defense can argue that, and during cross-examination and then during closing argument.
And I'm sorry, since we have 3 of these cases, I just need a little,
Yes.
little refresher on what Officer Garul said about what prompted the stop. And what I'm trying to get at is, to what extent did his testimony that would have been reflected in the tape actually contribute to the DUI conviction here?
Okay, so your question is whether whatever was in the video.
Well, so there was another officer who came and did the
Austin.
did the roadsides or
Yes,
whatever. And so did Garule testify, I just saw her and it looked like, she had a tail light out, and so I pulled her over without any indicia that she had been driving drunk? Or did he say she was all over the road and, and so I had to stop her because of that?
Yes. Officer G observed that she was weaving within the lane. She also crossed the median. She then jerked, I believe, in front of another car. So he observed many signs that the driver was intoxicated, and that's why he decided to conduct the traffic stop.
Okay.
Please.
That's all right, please.
Well, I'm just curious about, we have this 3-factor test from Lee, I think also Dunlap, and one of those talks about the prejudice. It seems like here the trial court found that, part of the prejudice is about leveling the playing field, but also, I don't want to affect the truth-finding function of the court. And that was part of the reason that the court decided not to give the adverse inference instruction. Didn't want to put a judicial thumb on the scale. But it seems like that's always going to be a concern with an adverse inference instruction. So help me understand how we look at that from Lee when we're talking about an adverse inference instruction.
Well, I think the adverse inference instruction here was just, she was not entitled to as a matter of law, and it would have been factually inaccurate because it would have instructed the jury of something that we don't know if it actually was true.
But isn't that always going to be the case with evidence deletion or destruction, even if it's inadvertent? In some cases, adverse inference instructions are given, and it is possibly affecting the truth-finding function. So I guess I'm just struggling with that part of Lee.
So here, again, she was not entitled to as a matter of law because it was, and as a matter of fact, it was inaccurate. But defense counsel had the opportunity to argue to the jury that the fact that it was distracted is because the government was hiding.
What is the inaccuracy?
The inaccuracy is that, we don't know what it actually, we don't know what the video recorded, right? Because we don't have the video. It was deleted. And if I have to argue, I think because we have Officer G testimony as to what he observed, that was evidence that it was contrary to what defendant was arguing. Defendant didn't have anything saying what the officer is saying is incorrect. But the prosecution had Officer G's testimony about what he observed. So it would have been a factually asking the jury to believe something that it would have been inaccurate.
Well, I just had this conversation earlier, but the instruction is about a permissive inference, right? So it says you may, basically, it doesn't use these words, but you may, but you don't have to, make an inference from that against the prosecution.
It doesn't matter.
That's the essence of the instruction, correct?
Yes, but it doesn't matter that it's permissive because still it would be inaccurate.
Couldn't the jury make that inference if they wanted to anyway? They have evidence that there is evidence that is not before them that was destroyed. So they can infer from that whatever they want, can't they?
Yeah, but still the instructing the jury would be inaccurate. The jury could infer whatever they wanted to, and counsel told them to do that. So I just think that the court...
The problem I have with your notion of inaccuracies, it seems to me the instruction merely tells the jury they may do what they may do anyway. And so I don't see that the instruction does anything except, as counsel answered, it emphasizes one part of the evidence, which is maybe a minor concern. But it certainly doesn't.
All right.
I don't even see that it puts a hand on the scale. It just says you can make that inference if you want to.
Okay.
Which you could do even if I didn't tell you.
I understand your point, but still it was within the trial court discretion to give or not to give. And I think in this case, it's just not an abuse of discretion, even if a different judge would have said, we're going to give this instruction. So that's the best way I can answer your question, that in this case, it wasn't an abuse of discretion. And
Well, in fact, it seems hard to me to think that it could ever be an abuse of instruction, not to give an instruction that doesn't affect things in any way whatsoever.
well, then there's no prejudice.
Well, if that's with regard to that instruction, the defense, I guess, today has gotten to the point where they agree that any one of the three remedies would have been appropriate. So, yes, I suppose so.
But your point, Your Honor, is that this instruction, the jury could do whatever. And in fact, again, the defense told them to infer that the reason why there was no video is because the prosecution or law enforcement were trying to hide something, and that video would not support the Officer G testimony. So they presented that to the jury, and there's no prejudice. Now, this takes me to my next related point, that the defense is arguing that Officer G didn't have an independent recollection of what happened. And that is not how I read the record. The officer initially didn't remember this case just based on the name. But after he reviewed the report, he had a recollection of everything that happened. And in fact, he said it was memorable because it was his first DUI after he became a supervisor. So he had an independent recollection, which again, this to me, the officer's testimony was comparable evidence to whatever was recorded in the video. And those are things that also the trial court, I guess, took into consideration in determining what the remedy for the sanction was. All right. And I would like to make another point that defendant argues that the case depended entirely on Officer G credibility or testimony. And our position is that that's not the case. Officer Austin's testimony corroborated that the defendant was showing many signs of intoxication, which lent support to Officer G testimony regarding the defendant's driving behavior, careless driving. In addition, the jury also had defendant's refusal to submit to chemical testing, which is additional evidence of guilt, and also the open container that was found in defendant's car.
So is that a harmless error argument that you're making?
Yes, if this court were to find that the trial court abused the discretion, which I think this record doesn't support that the trial court abused the discretion. Again, the defendant had the opportunity to cross-examine the officer who had independent recollection, and there was other evidence of guilt. And I would like opposing counsel to talk about this, but I just, as I was preparing for this argument, I realized, this has to do with the redacted court packs, the documents. And I didn't argue this in my answer brief because I didn't realize exactly. I argue waiver, which I think defense waived the redaction claim. In reviewing the record, it appears that the redacted copies were not made part of the record. And I realized that in reading the transcript of the June 28th trial, pages 201 to 203, it appears that they made copies of the redacted documents, and they labeled them, and I don't believe that those were made part of the record. And
Are they in the record in one of the other two cases?
I don't think so, Your Honor, because the record is combined, and but certainly not in this one. And again, I didn't argue, but as an officer of this court, I thought that maybe you want to check that because it just appears. It didn't make sense to me. Then reading the exhibits, I didn't see the redaction. But it was clear that the party was talking about redacting. The court said, make sure prosecution that the defense approves, and defense counsel said, no objection. When in this was the third trial, say I handed those out. I assume no objection because it's the same redaction. So it didn't make sense that there was some kind of mistake. So it appears that there was a copy of those, and it was given to the jury, but it's not in the record. And as this court knows, it is defendant's job to make part of the record all those portions necessary to substantiate her claims, and this court must presume that those portions would support the trial court ruling. But even if the documents that made it to the jury were the unredacted ones, in reviewing all the documentation, it wasn't highly prejudicial. It's mostly minor traffic offenses, violations, and the jury already heard that she had 4 prior DUIs or DWI convictions. So I don't see that as highly prejudicial if it happens that that's what made it to the jury. But it seems that the redacted copies are the ones that went to the jury, but we don't know because it's not part of the record. So unless this court asks any other questions, we ask that you affirm the convictions. Thank you.
I'd like to start by addressing the prior conviction documents portion. I do believe that the record was supplemented with the redacted copies of the prior conviction documents, and so those should be included in the record for all 3 cases. I would like to turn to the prejudice of the court's refusal to impose a sanction for the due process violation. I think that the court's finding that the jury instruction would have been inaccurate I think it was speculative of the court to presume that the evidence was more likely to be inculpatory than exculpatory, because as was being discussed earlier, in these kinds of situations, it will always be the case that we don't know exactly what the evidence would have shown. And I think that Ms. Munoz's consistent assertion that she was not impaired and that she was not driving poorly is sufficient to sustain a finding that this evidence had apparent exculpatory value before its destruction, and that it was more likely to be exculpatory than inculpatory. I'd also like to mention that the adverse inference instruction now has policy support under the Colorado Revised Statute 2431-902 as part of the Law Enforcement Integrity Bill that was passed in 2021 and went into effect shortly before this trial. That act provides that if an officer fails to activate or tampers with their dash camera footage during a contact with a member of the public, that there is a permissive inference in any investigation or legal proceeding stemming from that contact that the missing footage would have reflected misconduct by the officer. And so there is support now in the statutes for giving this kind of adverse inference instruction in situations like this, where a dash cam footage was properly made, but it was marked improperly, and that caused it to be deleted.
Does the statute require that sort of instruction?
I believe it does, yes, if it's either the officer fails to activate either dash cam or body cam footage, or they tamper with it. And tampering includes intentionally damaging, deleting, or failing to upload a video and audio under CRS 2431-901, subsection 6.
But we don't have a finding, do we, that the officer intentionally deleted the video?
No, but I think his failure to upload it in a way that would properly preserve it could be considered tampering. And I realize I'm out of time, so I would ask this court to reverse Ms. Munoz's convictions and remand for a new trial. Thank you.
Thank you. I want to thank both counsel for your arguments. They will help us a great deal in deciding this case, and thank you for the briefing and the other two related cases as well. You are now excused, and you can go ahead and clear out tables. And once they're done, counsel for the next case, which I believe is Ulrich versus Leprino Foods, can go ahead and come up. Okay, our next case is Ulrich, and there are some other names, I will skip them, versus Leprino Foods, 23CA769. When you're ready, and I know that you're pro hoc, so you don't have a registration number, but if you could please introduce yourself, that would be helpful.
I can. Good afternoon. My name is Andrew Gould, appearing pro hoc vice for the plaintiffs. With me is Robert Fishman, whose registration number is 21842. I hope to reserve 3 minutes for rebuttal. As this court said in Humphrey, the question of statutory employer status is generally one of fact. It is only when the relevant facts are undisputed that the question becomes one of law for the court to decide. But the district court here turned those principles upside down. Although expressly and correctly acknowledging the key factual dispute, it granted summary judgment under the regular business test. But the regular business test is a tool for resolving a legal dispute related to statutory employer status, not a purely factual one. And even RCI on appeal doesn't truly defend the district court's analysis, instead recasting the opinion as, quote, harmless error. But there was nothing harmless about the district court's erroneous analysis. Because the relevant facts to statutory employer status are disputed, the question was one for the jury, not a court. This court should reverse. In my time, I'd like to begin with the district court's misapplication of the regular business test, and then I'll address RCI's two arguments as to why this court should nonetheless affirm. Of course, I welcome the court's questions on any topic at any time.
If we could just skip over the regular business.
Sure,
test
of
piece.
course.
I don't know if my fellow judges have any questions.
I'm happy to answer questions.
I'd like to kind of cut to their argument.
Sure.
And I think the most important question for me is, what admissible evidence did your client present in opposition to in opposition to the assertion in the summary judgment motion that the decedents were acting in the course and scope of the contract when they were killed?
if I can, so there's a legal component and there's a factual component to that question, if I may address it. So first, in terms of course and scope of the employment, now that's RCI's argument, is that because we alleged in our complaint that they were acting in the course and scope of employment, that necessarily means that the statutory employer test applies. And that's not our argument. Course and scope is a different question about whether the work is contracted out. But let me jump to the factual component of your question. I think there are two categories of admissible evidence.
Well, hold on. Sorry, I processed
Sure.
it a little bit slowly. Are you so in the summary judgment context? You would agree that the structure is basically the moving party has to allege enough to shift the burden, and then if the burden gets shifted, then the non-moving party is obligated to present admissible evidence to establish that there's a dispute of material fact, right?
Sure.
So is your argument that RCI in their summary judgment motion didn't carry their initial burden?
No, I'm not arguing that they didn't carry their initial burden. I am suggesting, though, however, that we successfully rebutted it in our opposition. Again, we explained why the regular business test doesn't apply here. But again, as to the facts, right? So the key question here, the key factual dispute that the district court recognizes, were the victims engaged in activities related to pneumatic pressure testing at the time? That's the key factual question. And on that, in the summary judgment record and what we presented, there are two categories of evidence, or that's how I would characterize them. The first category is what RCI doesn't talk about on appeal, and that's Leprino's internal investigation, Mr. Grigorich's statement about how they theorized that it was Mr. Galarza, one of the three Ulrich employees, who loosened the lug nut, and that's engaging in depressurization at that time. Now, RCI has not addressed that on appeal. They focused instead on purely Mr. Galarza's statements within the police report. I'm sorry.
Where other than the police report is, and I think it's Grigorich?
Yes.
Where other than the police report are Grigorich's statements reflected in the summary judgment response?
It's only in the police report, Your Honor. So you'll find Grigorich's statement as part of the police report in court file 2153 and 54. Under cases like Callan, and I believe we cited this. Police reports are admissible as long as the underlying statements themselves are admissible. And here, again, I'm a bit at a disadvantage, at least as it relates to Leprino's internal investigation and Mr. Grigorich's statement, because they didn't make any argument related as to why that is inadmissible hearsay. So we haven't briefed that before the court because it wasn't raised in their answering brief. They instead focused exclusively on Mr. Galarza's statements to the paramedic as well as at the hospital. So I would say just based on that alone, based on that statement alone, which is unchallenged, that's enough to reverse. But let's say you disagree with me.
Well, I think what you need to tell us is what hearsay exception. Well, first, is it hearsay? And second, if so, what hearsay exception would apply to Mr. Grigorich's statement? So,
assuming it was properly before the court, I think that it would qualify as statement against interest, because at the time he's giving this is purely against Leprino's interest. They've got two dead people. They know that litigation is forthcoming. They have a good sense that it's forthcoming. So I think that's one thing. Another thing would be present sense impression, that he's giving right there what he believes to be his belief as to how the accident happened. And again, I'm saying this, I'm standing up and saying this to Your Honors, having not briefed the issue.
Sure, I understand.
But those would be the two that immediately come to mind.
Okay.
Unless the court has any questions about Mr. Grigorich's and Leprino's investigation, I'll move on to Mr. Galarza's statements. So Mr. Galarza's statements, they did argue on appeal that it was inadmissible hearsay. Again, we've argued that we believe it wasn't sufficiently briefed before the court, but let's assume you disagree with me and let's just discuss the merits of it. We think this would squarely fall within the excited utterance exception. We've cited cases in our reply at page 9. One of the cases that we've cited is People versus Ojeda. People versus Ojeda, and it's not a novel case, it just applies this court's well-settled precedent on the excited utterance. it says, we interpret the excited utterance exception liberally, and it can also apply after a lapse of time. Because keep in mind, there are multiple statements by Mr. Galarza. First, on the way to the hospital, the statement to the paramedic, and then later at the hospital, hours after the effect, to the officer. So both of those statements, in our view, would clearly qualify under the excited utterance exception as interpreted by this court's precedent. I don't think that they can meaningfully dispute that these statements weren't made under the continuing stress. He had survived, what was a fatal accident for two of his colleagues.
But counsel, didn't the officer first go to the hospital, see that he wasn't in a state to speak because of the recency of the shock, and so he left and then came back hours later and only then felt comfortable speaking to him? So isn't that some evidence for us to suggest that he wasn't in a state of shock, there wasn't any excitement going on at the time, the fact that the officer at that point did feel comfortable speaking to him?
Judge Sullivan, I would say, so that's in terms of the timeline, that's correct. From a legal standpoint, however, again, cases like Ojeda and the other cases we've cited on Reply 9, statements have happened hours after the event has passed, and so we would say that this is no different from any of those cases where the excited utterance exception hasn't been interpreted by this court as having to apply that very moment, but rather you can look, including a few hours later, that if under the circumstances, it can still apply under those circumstances, and we think that's the case here.
And we don't have any findings from the district court on these exceptions.
No, and that's absolutely right, and that's another point, because the district court didn't decide it on that ground. The district court decided this purely on the regular business test, which I'm happy to address, although I recognize Judge Grove wanted me to, unless the court has questions on hearsay or course of scope.
I actually have a couple of big picture questions.
Sure.
I know that the survivors of Mr. Jarvis successfully filed a workers' comp action in North Carolina, right? Mm-hmm. And did the survivors of the other decedent also do that?
I'm not sure, Your Honor. I'd have to look back at the record, and I'm happy to file a letter with the court to that effect.
Okay.
After the fact, I'm sorry for not being able to answer that.
I can tell you it's not in the record.
Okay.
I mean, I have the decision relating to Mr. Jarvis right here, and so I was just asking if you knew, because I was assuming that you represented both. But if
I
you
do.
didn't,
I do. I'm not aware standing here today. I apologize.
it'd be helpful if you could
Sure.
update us on
I will.
that. And that sort of leads me to my bigger picture question, and that is that workers' comp, as you know, is generally, you either get a workers' comp recovery or a tort recovery, but generally not both. And so in the conclusions of law on the North Carolina Industrial Commission award with respect to Mr. Jarvis, the hearing examiner says that Mr. Jarvis sustained an injury by accident arising out of and in the course of his employment with defendant employer, which is Ulrich, which proximately resulted in his death. Why does that not foreclose the argument that you're making here?
I don't think it forecloses it for this, just even under Colorado law, because course and scope is different. It's broader than in terms of statutory employer status.
Yeah, but this says arising out of and in the course of his employment, which is, I think, exactly the same language that we have in our workers' comp statute.
So I believe it is similar, Your Honor, but for statutory employer status. And so let me take a step back. And there are cases where an employee has recovered workers' compensation against one entity, right, but not necessarily against who another company claims is the statutory employer. And that's what we're saying here, is that RCI should not be considered his statutory employer. Under the statute, again, this is 841-401, the key language here is it's contracting out any part or all of the work thereof. And what we're saying here is that what RCI did not contract out was activities related to pneumatic pressure testing. And so we think it is consistent with the workers' compensation statute to say that even though one might say that this is would be covered under the Workers' Compensation Act for purposes of course and scope. It doesn't qualify for purposes of statutory employer, which is an entirely different analysis. Unless the court has further questions, I'd like to reserve the remaining of my time for rebuttal.
That's fine, thank you.
Thank you.
May it please the court, my name is Andrew Carafelli on behalf of Refrigeration Concepts, Inc., or RCI, registration number 25071. Judge Grove, I think you hit it right on the head here. Did the plaintiffs below meet their burden to oppose RCI's motion for summary judgment with any competent or admissible evidence? And we submit they did not. They relied on a number of hearsay statements, be it contained in a report or in a police report, that simply were not admissible below. And the lower court did not have to consider those in reaching its conclusion here and finding that RCI was in fact a statutory employer.
It seems that you're not really defending the court's regular business analysis. Is that fair to say? I mean, it seems to be that you're going a different direction than the court did.
Well, Your Honor, I think the court looked at the business test as were the Ulrich employees basically hired to do something that was in the scope of RCI's work. That's what the district court concluded. The plaintiffs want to now say, well, the question really is, were the decedents doing something outside the scope of what they were hired to do? And to do that, what they're trying again to rely on are these hearsay statements below that did not meet their burden to oppose the affidavits that we submitted.
I mean, I just want to, I don't mean to harp on this, but I'm on page 6 of the court's order. It says, plaintiffs allege that Quinones and Jarvis were conducting pneumatic testing rather than welding work as they had been contracted to perform. However, RCI's regular business, when considering the M&M management test, involves a scope of work that includes both welding and pipe fitting. I don't see how, like it says pneumatic testing in one sentence and then welding and pipe fitting in the next. And I don't know, is the court making a finding there that welding and pipe fitting encompasses pneumatic testing? I'm just not sure what we're supposed to do with that.
Well, I think the lower court judge said he rejected plaintiff's argument that the plaintiffs were conducting pneumatic testing. Because again, there is no evidence in the record below that the plaintiffs were conducting pneumatic testing whatsoever. I mean, even if you look at the hearsay statements they tried to rely on below, there's no indication that these decedents were engaged in pneumatic testing. In fact, Mr. Ortiz, one of the decedents, we don't even know what he was doing at the time of the explosion. Mr. Jarvis, at least according to the here statement of Mr. Galarza, says, I asked him to help me get a pipe to move over, so this is something we were going to put into the system, i.e. the pipe fitting or the welding that they were going to do. Again, there's nothing in the record below or in front of this court to say that these individuals were engaged in pneumatic testing whatsoever.
Can we talk about Mr. Gregorich's statements, which I understand were not thoroughly or maybe at all addressed in the briefing here. Can you address why you think no hearsay exception applies? I think the suggestion was what I've written down. Statement against interest and present sense impression might, obviously without limitation because it hasn't been briefed. I just want you to address those two possible exceptions.
Sure. Well, with respect to Mr. Gregorich's statement against interest, that would be the interest against Leprino, not RCI. Leprino is out of this case now. RCI is the only remaining defendant here. Secondly, it's not a present sense impression because under the law, one actually has to be observing the event when they make that statement. Mr. Gregorich was not observing the event at the time. Nobody saw what happened here on the roof, unfortunately.
Okay.
Well, counsel, let's say the police report is hearsay, and we are inclined to agree with you that no exception applies. The problem I'm having is that this court typically is not the first decider when it comes to whether a hearsay exception applies. We are in the position of reviewing a district court's decision on that. And as your opponent points out, sometimes these exceptions are close questions, right? An excited utterance, maybe 1 hour is enough, maybe 4 hours is enough. It depends on the circumstances. So I'm struggling a little bit with how are we supposed to make that decision without findings in front of us from a district court on admissibility.
And I understand that, Your Honor, and I know that the district court did not expressly comment on that. And my recollection is the plaintiffs below did not really raise these exceptions with respect to the hearsay argument. They did that when they briefed it to this court. So it wasn't really in the front of the court to address. They submitted these hearsay statements, the judge rejected them, and as we argued, this was just harmless error because the way he decided this case, ultimately, he couldn't have relied on the hearsay statements anyway. So his ultimate finding is really, I would say, harmless error not to address the hearsay arguments because it wouldn't have been appropriate for him to rely on them anyway.
How does this work at the summary judgment stage? Frankly, it's kind of unusual to have fights over admissibility of evidence on summary judgment. I can't remember that I ever did it when I was in practice, but it's just odd to me. So, I mean, you have, I guess you would have findings by the court, but it's not like findings based on live testimony. It's findings that are based on the papers that are in front of the judge. And so my question is, how would we be in any different position from the district court in assessing the viability of these hearsay exceptions? I mean, I guess my real question is, assuming that the court had ruled on this, would we be reviewing those rulings de novo or under an abuse of discretion standard?
I would submit you're reviewing it de novo, Your Honor. Here, again, the plaintiffs submitted these hearsay statements, didn't argue about exceptions or raise it below to even have the judge rule on it. So again, I don't know that this court has to go back and say, well, lower court, please, address these exceptions now because they've raised them on appeal if they didn't raise it the first time around.
Okay.
So if we're considering it in a de novo fashion, my question to you would be, should we consider it in the light most favorable to one party or the other? I mean, after all, these are allegations. They're, as Judge Grant pointed out, they are without detail. They might be sufficient depending on other detail that's missing here. How are we supposed to decide that without some guidance as to the kind of inferences we should make from it?
Well, I think, Your Honor, given the fact that this was at the summary judgment stage, as opposed to a motion to dismiss, where, again, you must take the allegations in light of most favorable to the plaintiff. Here, we have a situation where RCI submitted affidavits, and now the burden turns to the plaintiffs to rebut and submit opposing affidavits or deposition testimony or sworn answers to interrogatories to rebut or oppose that summary judgment motion. They did not do that. I mean, that's what this court, I would submit, should be looking at. Did they meet their burden below to oppose it? Plain and simple, even on a de novo review. I'm sorry, you looked like you had another question.
It's processing, but go ahead.
Just going back to Grigorich's statement really quick, and these are some of the comments that appellant's counsel made with respect to Grigorich's statement. He said Mr. Grigorich theorized that this may have been what happened on the roof. Well, again, speculation is not sufficient to defeat a motion for summary judgment in that regard. And turning to the workers' compensation issue, Judge Grove, you read from the Workers' Compensation Commission hearing order in North Carolina, where they found that these individuals, or at least Mr. Jarvis, were acting in the course and scope of their employment. I would submit there's almost an issue of judicial estoppel here, where the plaintiffs have already reached out to another tribunal.
No, but that's not before us, is it? I mean, that issue hasn't been raised here, has it?
No, I was just responding to Judge Grove's comment, though. But yes, we didn't raise that as judicial estoppel at this time, Your Honor. But the record is clear here that the plaintiffs alleged throughout all of their complaints that these individuals were hired to do pipe fitting and welding, and that they were working in the course and scope of their employment since they went to that job. Through 5 complaints, they never asked to amend the complaints whatsoever. So there's that issue. Then we have all the workers' comp issues where they've reached out and applied for workers' comp benefits based on that same type of argument. And so I would submit at this time, I don't think they can really argue otherwise that they were engaged in some other work that wasn't contemplated by RTI. So unless the court has any more questions, I would ask that this court affirm the lower court's granting of summary judgment.
We don't. Thank you.
Just a few brief points on rebuttal. And again, Judge Rove, I will get back to the court in terms of specifically what's happened with workers' compensation. But one thing I do want to point out is that none of the victims have sought workers' compensation against RCI, which I think is relevant here. My friend said that the district court rejected.
Can I?
Sure.
And we have plenty of time.
Sure.
I'm just curious. Could they have given the isn't this? Sorry, let me back up. It seems to me that's what the statutory employer status is for. Like there's this chain, right? There's Leprino, there is RCI, there's Ulrich. And it seems to me that the point of the statutory employer is that you are covered under workers' comp if you are injured. And are you suggesting, and I don't know, this is more your field than mine, that they could have also sought workers' comp benefits against RCI in addition to getting them against Ulrich?
Well, it's our position, of course, that RCI was not their statutory employer, and so they're not entitled to workers' compensation benefits. Let's say that this court disagrees and affirms the district court's ruling and that it's final, right? At that stage, we might be able to seek workers' compensation against RCI. I think there would be an issue with double recovery, right? I don't think we'd be able to double recover, right, in terms of the excess. But I think that would have to be worked out after the fact. But returning to our basic point is that it's our view that they are not the statutory employer.
Right.
And if I can, because there have been comments about course and scope, and one of the opinions we cited is the division's opinion in Calgar, which reversed statutory employer. I'd urge the court to look at the dissenting opinion in there because that's from Judge Roy.
Is that the electrical line case?
It is the electrical line case. And there in the dissenting opinion by Judge Roy, one of the things that Judge Roy talks about is how the plaintiff there was acting in the course and scope. And that's one of the reasons why he would hold that the statutory employer doctrine applies. Mm-hmm. The majority implicitly rejected that theory. And I guess in my very limited time, what I would say is, the hearsay arguments, they haven't been considered by the district court. I've never heard respectfully of an appellate court considering them on a de novo fashion because it would be for abuse of discretion. I see my time is up.
Okay.
I'm happy to answer any questions that the court has.
I don't think we have any. Thank you very much.
Thank you very much, Your Honors.
I want to thank both counsel for your arguments. They will be very helpful for us as we decide the case. Counsel are now excused, and a written opinion will issue in due course.
Thank you.
Thanks. Alex, are you take a break? Okay, we'll go ahead and call the last case on our docket today, which is, I've got it here. I'm sorry, I'm going to mispronounce these names. Tarian versus Can. Correct me if I'm wrong, but. So you folks weren't here for the spiel at the beginning, so let me just run through that. This is Division 2 of the Court of Appeals. I'm Matt Grove. With me on Division 2 today are Judge Sullivan and Justice Martinez. We're here for argument in case number 23-1116. Just a couple of minor things. Remember that we are being recorded, so if there's any confidential information, just keep that in mind. If you have any electronic devices, please turn them off. If you need to move the podium up or down, there's a toggle. For the appellant, you're free to reserve time. That's up to you. You can tell us how much you want, but I'm not going to jump in and remind you. When you begin, please state your attorney registration number and your name. And unless anybody has any questions, we're ready.
Your Honor. May it please the court. My name is Dean Batchelder. I'm with the law offices of Berg Simpson. My bar number is 38425, and I'm here on behalf of plaintiff, appellant, Mr. Tarian. I apologize. We raised 3 points in our briefs. In our opening brief, first, just for context, First, that it was error under 702 to permit the testimony of Mr. Mitchell. Second, that the district court erred in not making specific findings as required under Colorado case law when it ruled on our 702 motion. And then third, that the error was not harmless to Mr. Tarian. I'd like to focus on that first point, and as the court has questions, obviously I want to talk about what you want to talk about more than what I want to talk about. Before jumping in on 702, I do want to point out on the specific findings point under 702, the response from Ms. Kane, and I apologize, I wasn't counsel below, so I apologize if I mispronounced that, Ms. Kane.
We'll find out.
We'll find out. No disrespect is intended. My name gets mispronounced a lot. Anyhow, my point is that the response from Applee wasn't a substantive response on the specific findings. It was that we didn't preserve it. We disagree. We do believe we preserved it. My point here is just that there wasn't a specific response substantively. We think the court was required to make specific findings. It failed to make specific findings, and I think that was error, and I think on that basis alone, that Mr. Tarian would prevail. Shifting back to that first point, the 702 test, this court is certainly aware that under a state of Ford or other cases, under Colorado Rule of Evidence 702, it's a 4-point test. The specific point in that test here on this appeal is that the scientific principles underlying the testimony, they have to be reasonably reliable. And our submission is that the underlying points that Mr. Mitchell was relying on were not appropriately reliable.
The underlying points that you're talking about are basically concerning the facts of either the accident or his investigation of the accident.
Well, the specific point we're making on appeal is that he didn't have a basis to say, he had a basis to talk about the turning radius of the vehicle. He had a basis to talk about, in his experience, how that plays out in real life. He didn't have any basis to talk about, and it would be speculation, we think, for him to talk about where the collision took place.
Wasn't that the point of his testimony? I mean, your client has the burden, right, to show by 50.1% or whatever the number
Yes.
is, that the accident happened on his side of the line. And it seems to me that Mr. Mitchell's point was, we can't tell that. And it seems to me that if that's true, that seems relevant. That is that he's not saying it happened in one place or the other. He's saying the plaintiff cannot carry its burden to show that to show by a preponderance that it happened on his side of the line.
I think that what he was, I mean, the record reflects what he said, but the way I took what he said was, here's the turning radius of this year, make, and model. Here's the car. It's 18 feet. Here's how that plays out in real life. He likely was on pretty solid ground offering an opinion about that, what the easternmost point would have been. And then to respond to your question, I think he went beyond what you just said, Your Honor. I think he said, especially with that demonstrative that was part of his report and that was offered at trial, he's got the circle, he's got the line, the red line coming in and the red line coming out. He's offering, I think, essentially an opinion as to where it did occur. I think he went beyond kind of the negative statement of it couldn't have happened more. Am I being clear with the references to the lanes?
Why wouldn't that just be a matter for cross-examination?
Because I think, as we pointed out in our brief, that the reliability speaks to admissibility, not to weight. And I think that's an error that the court made.
You've used reliability in an interesting way, because it seems to me that what you didn't really challenge was the methodology or his qualifications. Is that fair?
It's certainly fair that we did not challenge his qualifications. That's certainly true. Then as to the, I believe you said methodology.
Yeah, I mean, the science behind accident reconstruction.
I think that the difficulty for Mr. Mitchell is he went beyond kind of that negative statement. In his report, he certainly said, it's at 799 in the record, he opines that in reality, Mr. Tarian made a wider turn than that minimum turn. I think if he had talked about just that minimum turning radius, he would have been on, again, my job would be much harder here today. But he went beyond that. He offered opinions, whether in that drawing or in just raising the question or suggesting that it happened on this side or that side of the line.
My recollection is that he said that because he said that the turn didn't start from a dead stop. That is that your client said that he was, I think, third in line and that he did the U-turn as a normal person would do a U-turn. That is, he didn't come up to the green arrow, stop, and then do it. And that if you start from anything other than a dead stop, the turning radius is going to be wider than the minimum turning radius of the car. Is that a fair summary?
I think that is a fair summary, but I don't know exactly how Mr. Tarian testified that he took the turn, but he was certainly rolling when he went into the intersection, if I recall. So I'm not quibbling with your summary. But our point is that can be true, but there are a lot of things that Mr. Mitchell doesn't know or didn't know that speak directly to where Mr. Tarian, would have ended up. Did Mr. Tarian swing out to shorten the radius? Did he go into the intersection? Where did he start? This was all on cross-examination. I believe it's May 15th at 110 and 111 of the transcript. Pardon me, I apologize. That Mr. Mitchell admitted he didn't know where either Ms. Kane or Mr. Tarian started their turns. And so it can certainly be true. It's a fact, right? Here's the turning radius of this car. It can also be true that most people, and consistent with Mr. Tarian's testimony, get a little wider than that. But it's a leap from that, it's guesswork from that, to the drawing that he offered, where he's crossing that third, fourth lane. These lanes are 10 to 12 feet. That's 2/3 of the turning radius, right? I mean, so my point is, it's a fact, the turning radius. It's a fact that most people get out beyond that. Anything past that is guesswork. And I think that's what happened here, and I think that's what's...
Yeah, I mean, your motion was a Shrek motion, correct?
Correct.
So, I mean, when we talk about Shrek, we're talking about trying to prevent junk science from reaching the jury, right?
Correct.
Shrek is not really concerned about the fact that the expert doesn't necessarily have all of the facts and data that might be helpful to the expert opinion, correct?
Certainly, the standard under Shrek is not perfection, and we're not suggesting that it is, or total knowledge of the facts.
And that's why experts are allowed to testify, to something less than certainty when offering their expert opinions. And it's really up to cross-examination to point out that you have an incomplete data set here. You have incomplete facts. So I'm just picking up on a little bit of what Justice Martinez was getting at, in that this is really about the fact that it would have been helpful if Mr. Mitchell had more facts, had more information, but he didn't. But that's really a subject for cross-examination.
But I think all of that's true, but I think he went beyond what might have been permitted. He had no facts. It wasn't that it's not certain, it's uncertain the other way, and that he's essentially guessing where on that intersection Mr. Tarian would have completed his turn. I appreciate it may be a close question, and I'll acknowledge that Mr. Mitchell did couch his opinion, right? I mean, he was fairly careful, and I think that makes it a closer question. I want to be upfront, right? It's not a slam dunk. He's not saying up is down and down is up. But I think, and we weren't challenging his qualifications, and we weren't challenging the turning radius or the fact that most people get a little beyond that. But a mechanical engineer to talk about, well, the next 10 or 12 feet and where it might have happened, I think that's guesswork. I appreciate it may be a close question, but I don't think there's a reliable methodology to his conclusion that it could have happened here.
You had an expert too who opined on the location of the collision.
We did, you're right.
What information did he have or she have that Mr. Mitchell didn't?
It was he, I believe, Cilio, and I hope I'm pronouncing that correctly as well. I don't know that he had different information. I think that one thing that's relevant here is that his opinion was, there was other testimony, right? Mr. Tarian testified, Ms. Kane testified, and then the two experts testified. But the two folks in the collision testified. And I think Mr. Tarian was consistent that he ended up in that third lane, and Ms. Kane was inconsistent both about where she ended up and where Mr. Tarian ended up. Sorry, I guess to put a fine point on it, standing here, I couldn't tell you what the plaintiff's expert relied on, but it wasn't more information.
Okay.
I will say that's not before the court because that was not cross-appealed. But I think if we're just talking about the turning radius, that's one thing, but experiential or crash data or DOT statistics about how these things play out in real life is a different matter. And I think we crossed the line there.
Did this crossing of the line occur in the testimony, or did it also occur in the report?
I believe in both. I think, and I would highlight that demonstrative aid that was. I mean, I think that kind of encapsulates our position about what is difficult or what is wrong with this testimony that he's.
Well, I thought, and that confuses me too, actually, because I thought the point of the demonstrative was to show, or that he testified that in the demonstrative, he has the contact occurring right at the line for the reason that he doesn't know where it occurred. He can't deduce that. Or he can't opine on it.
I think he did and again, I want to credit him. Like he was somewhat cautious. It's making my job more difficult, but I think it's still an issue. I want to be upfront with the court here. But to your question, I believe Mr. Mitchell in his report opined that the furthest east Mr. Tarian could have been was that lane 2 coming into lane 3, and then that demonstrative has the collision occurring on the marker between 3 and 4. I think he did testify that we don't know for certain, but he did offer that demonstrative, or he testified as to that demonstrative. Am I being responsive to your question, Justice?
I think so. So are you saying that the demonstrative is inconsistent with his testimony by one lane?
Pardon me. I guess what I'm pointing out that in his report he's more conservative than he was with that demonstrative, but I think the error is him testifying at all beyond what is the easternmost point that the collision that Mr. Tarian could have completed his turn. I think he would probably be on fair ground saying that, but anything other than that is a difficulty, or it's objectionable from our perspective. And I do think, I'm happy to answer your questions, and I'm glad I've been able to. I do want to say on that second point, the district court just didn't make any findings. I think the order, it's 4 sentences long. It didn't engage at all with 702 or the arguments. And the point to some of the questions here that it be handled on cross-examination, that speaks to weight and not as to admissibility. And I think it was an admissibility
But isn't that
question.
exactly basically what the trial court said was kind of like Judge Grant said, is this doesn't seem like a Shrek issue. This seems to me like objections that need to be made at trial because your Shrek motion is not challenging his expertise as an accident reconstructionist, nor is it challenging accident reconstruction. It's instead challenging the specific opinions that he comes out with.
Well, I think...
Isn't that, in essence, what the trial court said? No, not in those words.
Well, I mean, the difficulty is the trial court didn't come out and say that, but I think that's the upshot of its order. Mm-hmm. But that's guesswork on our part, and we didn't get the findings that are required. I think that's a difficulty for the court. But I do think...
But if the trial court is right, I mean, if we're interpreting that right, and the trial court is saying this isn't really a Shrek issue, then it's not required to make findings, is it?
Well, I think under 702 it is required to make those. I mean, if the conversation is going to be, is the error harmless or not, that, or is the issue going to be, is it a 702 error or not, that's separate from what seems to me to be fairly straightforward, that the court is required to make specific findings under 702. It was a 702 motion.
How assuming that's right, how would that have helped? Because wouldn't the court's findings have been accident reconstructionism is based on some underlying scientific principles, it's not junk science, and this man's qualified. Those are the findings, right?
Well, I don't know. I mean, there aren't any findings from our point of view.
But those would be the findings if, in fact, in other words, the findings would not have spoken to what you've been arguing about, which is whether he went too far in his final opinion.
Well, I think the court, respectfully, I think the findings should have addressed, they need to engage, there's case law that says they need to engage with the objections made, and the objection made, in part, we had other objections, but those aren't on appeal. But here, the issue was he went further, and he didn't have a stated basis for going further. So I have about a minute left. I'll reserve that. Thank you, Your Honors.
If you could start with our most burning question about the pronunciation of your client's name, that would be great.
May it please the court. Your Honor, we were also not counsel at the lower court level. I believe the correct pronunciation is Khan or Can, but I cannot state that with certainty.
Okay.
My name is Charles Hall, bar number 44955 on behalf of Applee Amanda Khan. At counsel table is my co-counsel, Karen Wheeler, number 16884. A threshold question before the court is whether by neither conducting voir dire or of Ms. Khan's expert engineer, Garrick Mitchell, or making a contemporaneous objection at trial to his giving expert testimony, Mr. Tarian waived for purposes of appeal the issue of reliability of Mr. Mitchell's testimony.
So is your position then that the court did not rule or it deferred ruling on the 702 motion?
Yes, Your Honor, and we think the order is actually clear in that regard. In looking at the order, the court specifically allows for both the possibility of voir dire and for a contemporaneous objection to be made at the time of trial. And there really would not be a good reason for the court to allow the voir dire and subsequent objection if it was making a finding as to the admissibility when it ruled on the 702 motion. We submit that the order is actually consistent with the concept that while there is a preference for deciding expert endorsement requirements pre-trial, in certain circumstances, especially with regard to matters such as the incremental probativeness of proffered expert testimony, that it may be necessary to withhold ruling until later. And it appears to us that Judge Baum's order was consistent with that principle. The exclusion of Mr. Mitchell's testimony was denied at the time the order was issued based on the statement in the briefing that was before the court at that time. But it expressly left the door open to consider the admissibility of that same expert testimony at the time of trial. And the justification put into that order was that, quote, plaintiff's stated reasons do not provide a basis to exclude the testimony of Mr. Mitchell under Rule 702. They rather appear to be questions proper for either voir dire or cross-examination. It's axiomatic that voir dire occurs before the admission of expert testimony. So if the court order was intended to offer a definitive ruling in that regard, either admitting or excluding Mr. Mitchell's testimony, it would not make sense to invite further voir dire in the order itself. And additionally, because no definitive ruling was issued on the question of the admissibility of that.
I think it's maybe the problem I'm having here is just a matter of words we're using. You say it's not definitive. It's definitive as to the motion's been denied.
It is definitive.
The court went on basically to say you can raise whatever issues you want again later. It's kind of the way I interpret it. So it's actually definitive, but also does not preclude raising the same issues, I suppose. Although the court's been pretty clear that he thinks what they're really talking about is something other than in their motion, I think.
I agree that I think what they're talking about is something other than in the motion, but I would argue that the definitiveness of the ruling is with respect to the motion based on what was there. And the invitation to voir dire would afford the court an opportunity for additional context to come out on which it could base its ruling.
Okay. I understand. I think I was just quarreling with you about the use of that word.
Understood. And taking the viewpoint that the ruling was not definitive, that dovetails also with Colorado Rule of Evidence 103, showing that the basis for an error can't occur without a definitive ruling on either admission or exclusion. And because we don't have that in the 702 order, error in that order is not an appealable issue. And then considering the court's order, I think another issue here also raised in the Ruibal v. People case, which was cited by Mr. Tarian as well, 432 P. 3rd 590. In addition to citing the Rector case for the proposition that it's okay to delay the decision on the admissibility of expert testimony, the court also has a statement in there concerning that the trial court has the discretion to determine whether or not a Schreck analysis is even required in the first instance, and that the specific findings Mr. Tarian is arguing needed to be made are required where a proper Shrek challenge has been raised. And it's our view that the trial court order is entirely consistent with both of those statements, that the initial ruling on the 702 essentially delayed resolution of the expert admissibility issue to allow for additional context to come through the process of voir dire and afforded the opportunity for a contemporaneous objection to be made at the time of trial. And the order on Mr. Tarian's motion did not shut the door to the admissibility question and whether it could be excluded at trial. And it rather left the door open deliberately to that challenge. I think additionally, when we look at some of the cases providing examples where instances of pretrial motions were insufficient to preserve issues for appeal, it's notable, for instance, People v. Heiss, which we cited at 738 P. 2nd 13, and Bernacchi v. Brown, which we cited at 471 P. 3rd 1234. In each of these cases, there was a clear, definitive ruling with respect to admissibility, and yet it was still not enough to preserve the issue for appeal. The Heiss case also discusses another case, Uptain v. Huntington Labs, and compares it with a case Higgs versus District Court. And those cases reach different outcomes on this same issue of whether an issue had been properly preserved by a pretrial motion. And significantly in Uptain, the court held, quote, the precise issue had previously been determined by the trial court in a ruling on a motion in limine. And again, the same really can't be said here, that the precise issue before the court on the question of admissibility had been decided in that 702 pretrial order. Now, in the rebuttal brief that was submitted, Mr. Tarian also argued that repeating the objection made in the 702 motion would not have gained anything to have it just be summarily rejected. But we would submit that this, to a degree, misapprehends the import of the 702 order in this case. Judge Baum's order expressly left that door open to allow that to be considered by the court with the greater context provided by voir dire. And again, that's consistent with those statements in Roybal that it's sometime appropriate to delay this ruling, especially where it involves matters such as the incremental probativeness of expert testimony. And additionally, based on that order, objecting at trial would not have been repetitive, nor is there a reason based on that order to believe that it would have been summarily rejected. In fact, the court seems to be inviting Mr. Tarian to do exactly that. And so rather than framing it in terms of it being repetitive, it would have been, in essence, a renewed objection that's expressly authorized by the court's prior order, and which presumably would have been considered by Judge Baum in the light of any voir dire that was then conducted, and that would have afforded the court the opportunity to either sustain the objection at that time if Judge Baum deemed that appropriate, or to make the factual findings on the record that Mr. Tarian now submits are not there but should be. Further, even if this issue had been properly preserved, Mr. Mitchell's testimony was nevertheless appropriately admitted because it had an adequate basis, it was not speculative, and the law is clear that simply because an expert's testimony is stated in terms of a possibility,
Why wasn't it speculative? I mean, that seems to be one of Mr. Batchelder's main points here. Is that your expert didn't see the accident. He didn't examine everything. He looked on a website to figure out what the turning radius was. He didn't know the speed when the turn was initiated. He didn't know the tendency of the drivers or anything like that. It seems to me that there is a degree of speculation there as to what happened, right?
Well, I disagree that there was speculation there. I think the substance of his opinion can really be distilled to the opinion that Mr. Tarian made a U-turn wider than the minimum turning radius of his vehicle. And this is based on the mechanics of a U-turn, which require the driver to enter the intersection before beginning the turn the wheel to initiate the actual turning motion, and then straighten the wheel to come out of the turn. And Mr. Mitchell properly qualified his opinion to identify the limits of that opinion based on the available evidence so as to avoid exactly that speculation. The jury heard that he did not know exactly where Mr. Tarian started or ended his turn. And he acknowledged the limits of the available evidence, given that there was no contemporaneous police report that was filed. But also, absent his opinion, the jury may have been left with the incorrect impression that Mr. Tarian could have completed the U-turn at the minimum turning radius, which itself would have been a misleading impression. And so accordingly, his opinion is giving important scientific context to the difference between the theoretical minimum turning radius for this given vehicle and the actual mechanics of a U-turn completed by a vehicle turning at an ordinary speed. And that opinion is entirely consistent with Mr. Tarian's testimony, where he stated that there were cars behind him in his lane, and so he was not, quote, inching along as he made that turn.
Do you agree with your opponent that there might be a case where the expert has such limited information, such limited data that, yeah, maybe his qualifications are sound, maybe, he is practiced in accident reconstruction, which is a sound science, but at some point, if he has such limited information, it does become a Shrek problem, a reliability problem. Do you agree with that, or is it always just going to be a cross-examination question?
I guess 2 points on that. I think on a different set of facts, perhaps that could be a case. The other point I would make is that I don't think the order on the 702 motion is limited to a cross-examination question.
Voir dire, sure.
The voir dire component is pretty significant to what the court order is addressing. And in that sense,
But let's assume his qualifications, no one disputes that he's an expert. He's done this a million times. And no one also disputes that accident reconstruction is a sound science. It can be a reliable science. I'm just wondering, in the right case, if there's just a mountain of information that is not available to the expert for one reason or another, is that a Shrek problem?
I think it can theoretically be, yes. I don't believe that's the case here on these particular facts.
Explain to me why. So, envision this. The expert says, that seems to me close here, but the expert says, I've looked at all the evidence and applying my knowledge and understanding of reconstruction, I can't conclude who is at fault. Why would that be a Shrek problem? As a matter of fact, that's something that I imagine the defendant would want to introduce.
Well, I don't believe making the ultimate conclusion of fault or even the ultimate location of the accident. It would be a Shrek problem if there were not a sufficient factual basis for the expert to offer any meaningful expert opinion. Whereas in this case, Mr. Mitchell's...
Isn't it a meaningful expert opinion to say that the expertise does not lead you to a conclusion here because of the lack of information?
Well, if the facts are so limited that the expert can't reasonably reach the conclusion they do, then yes, I would have to agree with that. But I think Mr. Mitchell's testimony is fairly clear that he is not offering an opinion as to the precise location of this accident. In fact, his testimony at page 95 of the May 15 transcript specifically says, nobody knows, we do not know. Nobody knows exactly where the point of impact on the roadway was. We just don't know. And I see that I'm out of time. I would ask that the court affirm the trial court and the accompanying jury verdict. Thank you, Your Honors.
I just have under a minute here. I did want to, Justice Martinez, maybe I misheard you. We are arguing consistent with our arguments below. At 787 in the court file, we did raise this specific issue. That we raised other issues, but we did raise this issue. I do want to, in the last moments that I have, the court's order is 4 sentences, and we're hanging a lot on that. I think it wasn't disputed on the merits in the briefing that the court's order was appropriate or made the specific findings. And I don't think this court can kind of conjecture as to what the court really might have meant. If I lose on 702, I lose on 702. But as to specific findings, I think that's a requirement of the law. And the court's order, those 4 sentences, it doesn't leave the door open. It rejected the specific arguments that were made. And I see I'm out of time. So we would ask respectfully that the court reverse and remand for proceedings consistent with that. Thank you, Your Honors.
Thank you. I want to thank both counsel for your arguments. You're excused. A written opinion will issue in due course. That does it for our docket for the day. Have a nice afternoon, everyone.